Hello everybody and welcome to the webinar. This is the 6th webinar as part of our series we're hosting for people to share and learn during the coronavirus crisis. As usual, this webinar will be recorded so that others will be able to see it and watch it later on, and that will be available publicly and will be on our Be Human website for people to access from YouTube. So the webinar today is specifically around housing related issues. So for those that have not joined us before, this is how to participate today. So we have some fabulous speakers that have agreed to come and talk about the subject. If during the presentation you want to ask a question, there's a type-in box. You can either raise your hand like this and we'll take verbal questions at the end of the presentation, or you can use your questions panel and you can actually type in questions and I will collate them on behalf of our speakers and then ask them verbally on your behalf. If you're on an iPad, thank you Julie for sending us this picture in. If you're on an iPad, it's a slightly different view. So this is the view from the iPad, but there's still the option to put your hand up or ask a question via a text box. Oops, I've gone backwards, wrong. Okay, so what to expect? We're focusing this webinar on housing, specifically for those who are disabled. So the webinar is going to cover possession, homelessness, ASBOs, disrepair matters and unlawful eviction that affect disabled people. The webinar will also cover the impact of the coronavirus on areas of housing and provide some examples of the questions that people are already asking or issues that they're facing. And Ola and Priya will be able to offer some solutions. So without further ado, thank you so much, Ola and Priya, for joining us. I am now going to mute myself and hand over to you. Thank you.
Hello, good morning. My name is Ola Akinyode. I was a solicitor with Disability Law Service since October 2018. Okay. What I would like to do, first of all, as you see on the first slide, is just briefly talk about what we as a charity do. Okay, so we're a charity providing free legal advice to disabled people since 1975. So we cover areas of housing, community care, discrimination, employment and welfare benefits. The housing and community care and employment, we do offer advice and some representation. Okay, with the housing community care, we're able to offer full representation under a legal aid contract, and welfare benefits, it's simply a phone advice line. Okay, so the legal aid, as I said, legal aid contracts are in place for housing and community care. So basic free legal advice is provided to disabled people, adults, children, and their carers, wherever located. Okay, so 97.2% of these donations go directly into providing services to disabled people. When I say 92.7%, 97.2%, these are donations we receive directly from other charities or from organizations. So these go directly to helping our disabled clients. So what I would like to do then is, before going into deeply into the housing matters, is that talk about what we under housing, what we do, Disability Law Service. But to be eligible, you under legal aid, you would need to the area of housing which the client has to fall within the scope as set out in ASBO, and the client has to meet the means test and the merits test. The means test is basically your income and capital, and the merits test is basically the strength of the case and the likelihood of success up to 50%, and the benefit to the individual and the public. Next slide. Okay. So the scope of work undertaken by DLS under housing legal aid are homelessness assistance, which is to do with the reviews and appeals. So I'll be talking about this and finishing off each area with the COVID-19 regulations and how this has impacted on this area. I'll be talking about that. And then I'll move on to possessions, which is we assist with defending possessions, Section 21 or Section 8 notices. I would also be talking about this and talking about the impact of this. My colleague, who I will then hand over to, will talk about unlawful eviction. That's Priya. She would introduce herself shortly. And she would also talk about disrepair matters. Okay, and then I will follow up and talk about, this is further to the unlawful eviction, which Priya was spoken about, talk about protection from harassment in the areas of injunctions. This could be in relation to harassment from the landlord or neighbors. It's in the context of housing anyway, so it's not just a general harassment. It has to be in the context of housing. Okay, and then I'll finish up by talking about antisocial behavior and the COVID-19 impact as well. Right, so I'll just go straight into it. So homelessness assistance and reviews, which we cover. So this is for persons who are homeless or threatened with homelessness under Part 6 and 7 of the Housing Act. Homelessness, generally people assume when you say homelessness, it means you ordinarily or not got a roof over your head, and that's the all and or in and all out of it. But the definition of section of homelessness and statute under Section 175 of the Act says a person is homeless if he has no accommodation available for his occupation in the United Kingdom or elsewhere where he can live, or person is also homeless if he has accommodation but he cannot secure entry into it, or it consists of movable structure, vehicle or vessel designed or adapted for human habitation, and there's no place where he is entitled or permitted but to place it and reside in it. The definition also includes homeless if it's unreasonable to continue to occupy an accommodation, maybe due to domestic abuse, perhaps as a result of natural disaster. So that's one area which a lot of people are not actually aware of, that you could actually be homeless if your property is unreasonable, but you would have to take the next step and make an homelessness application, obviously. And another final definition is homeless if likely to be without a home in 56 days or following a receipt of a valid Section 21 notice under the Housing Act. So when a person basically makes an homelessness application to a local authority, which is then the next step if they're homeless, that person would ideally wait for a decision to be made on their application. Local authorities have a duty under the Homelessness Reduction Act at the onset to assess the person's needs. So that's the first thing they do. Second, to try to prevent homelessness when someone's threatened with homelessness. And 3, to help relieve actual homelessness at an early stage. Provided they're eligible, as I said previously, we will take such cases under housing legal aid contract. Next slide. So prior to the Reduction Act, 2017, only limited advice and assistance duty was owed to people found not to be in priority need. Okay, that has changed. So right now, anyone who are authorities, the initial thing is to carry an assessment, regardless of whether they're in priority need, carry an assessment and try to follow the steps which I said before, assess, relieve, and prevent and then relieve the homelessness. To recap, local authority still has a duty to take reasonable steps to prevent or relieve the homelessness, as I stated, if it has reasons to believe that that person is homeless and they're an eligible person, pending their inquiries. So the prevention stage would basically involve attempting to discuss with the individual landlord to prevent eviction or to stop the eviction going ahead. This is step the authority will take, or in terms of providing relief where the individual is already homeless. okay, then they can provide interim or emergency accommodation pending the conclusion of their inquiries. Okay. So when someone approaches a local authority, as I stated before, they initially do an assessment. If they can prevent the homelessness, they will do it. If they can, and it proceeds, and the person is now at a relief stage where they have to provide emergency home, they can provide an interim or emergency accommodation pending the conclusion of their inquiries. So if the person has become homeless or remains homeless after the 56-day relief period, which is the period local authorities are expected to have completed all the inquiries into the homeless application, then the main housing duty will arise if the person is found to be in priority need and not intentionally homeless. Next page. Right, so when the individual receives a decision following the inquiry, the decision letter is then known as a 184 letter, a section 184 letter. The letter would ideally either say that the individual is owed a duty under section 193. This is a duty to a person in priority need who is not intentionally homeless. Not intentionally homeless meaning that they left the property, the previous permanent residence, not due to a fault of their own. They were not intentionally homeless, maybe as a result of rent arrears. So the local authority, unless they refer the person to another authority, okay, perhaps due to the individual having local connections with another authority. So I think what I probably need to do is explain a bit on that. So what it means is anyone can make an application to any local authority. The local authority would then decide if that person has local connection. If they don't, and they have a local connection to another local authority, they would then refer that person, once they've completed the assessments and given a decision letter, they refer the person to the local authority, stating they do have priority or needs and they're not intentionally homeless, but the other local authority would then take over and continue with the housing duty. So, which means they will then take steps to find and provide suitable accommodation, which will now be a temporary or permanent accommodation. Alternatively, the letter may confer that no duty is owed due to the person either not being eligible because they're not eligible or they're not in priority need. Priority need usually refers to disabled persons, pregnant women, vulnerable persons, adults, elderly, I mean. So those are people usually in the priority category. The letter may also confer a right to ask for a review of the decision under Section 202 of the Housing Act. And this has to be done within 21 days. So it's not all over if the local authority give a Section 184 letter and they say they hold no duty to this person. The person most likely will have a right to review. This would have to be requested within 21 days of that decision letter. At DLS, Disability Law Service, we are able to assist, advise, and offer full representation under a legal aid contract. As I said, if the review under the Section 202 is successful, then basically it means the local authority would then withdraw their refusal letter and continue to offer the duty under 193 to the individual. If it is unsuccessful, then what we also do at the Disability Law Service, we can also advise and represent the individual, which would then be within 21 days of the decision letter, the refusal of the Section 202 decision letter, which has upheld the initial letter. If so, we would then be able to assist under Section 204 appeal to the county court within 21 days on a point of law. So we're able to do that. Okay, next slide. Right, so that's briefly about homelessness. So during the COVID-19 pandemic, during this outbreak, if you know someone who needs help, or you're also a person who's likely to be homeless, this would have applied to that person. So at the moment, councils are working to find accommodation for homeless people, regardless of eligibility and whether they're previously turned down or not. So if anyone has previously been turned down, accommodation or a decision letter, 184 decision letter did not work in their favor, this would not bar them from approaching the local authority in this pandemic, and the local authorities are working hard to provide accommodation at the moment. Obviously, it wouldn't be permanent. It would be an emergency or interim accommodation to such person. So, as I said, it means you can contact the council even if you've been turned down in the past. So even if an homeless application was previously rejected, you may not be able to visit the council in person as they are closed buildings, but they are still available to be contacted by phone or email. The government guidelines are that people should stay at home for 3 weeks stay at home duration, which has now been extended for a further 3 weeks, as you would all be aware recently. No one should be faced with the threat of being made homeless at present. So landlords and agents and tenants will need to work together and show goodwill in order to comply with public health guidance over the next coming weeks. Next slide. Another area which we cover under disability law service is possessions. We are able to assist in defending possessions, claim for possessions under Section 21 or Section 8. So these type of procedures which a landlord needs to apply to obtain possession will depend on the tenancy agreement and the terms. So a landlord will obviously only use the one that pertains to them, in Section 21. Okay, I'll go more into that later, or Section 8, or it could use a combination of both. So most tenancies in England and Wales are short-hold tenancies, which were introduced in the Housing Act 1988. Possession of an individual's home starts off with the individual receiving either 1 or 2 notices, or both, as I stated earlier. Section 21 notice of seeking possession, which gives you 2 months notice to leave the property. Section 8 notice. So what I want you to do is keep in mind what I've just said. A Section 21 notice gives you 2 months notice to leave the property. So when served in the appropriate manner and form. Section 8 notice, which is a notice of possession, is on one of the grounds available for a breach of the tenancy agreement. So before a landlord can use a Section 21 notice, next slide, please. Okay. So, as I said, for a landlord, the landlord can use this notice if they wish to end your tenancy. That's the Section 21 notice after the fixed term. The landlord does not have to have a reason. This is the beauty of Section 21 notices. As long as the date on the notice coincides with the end of the fixed term, and it is also issued not less than 4 months into the tenancy. So an example is if the tenancy agreement is for 6 months, hypothetically, so from 1st of January to 30th of June, the landlord will have to wait for the first 4 months, after the first 4 months, before issuing that notice. So, which will be either the end of April or beginning of May, 1st of May, before issuing the 2 months notice to end at the end of the tenancy, which will be the end of June. If the landlord intends to use a Section 21 notice, then for this to be valid, the landlord should have used a valid Form 6A and complied with the requirements of Section 21. Some of which are that the landlord must have registered the deposit, provided details of where it is deposited to the tenants within 30 days of the receipt. They must have provided electric and gas safety certificates and confirmation if it's an housing occupation that it meets with such requirements. The landlord does not need to meet the requirements. If the landlord does not meet the requirements, I beg your pardon, then the notice is invalid. So the rules regarding Section 21 are very strict. the landlord needs to comply. There is a further list of things they need to comply with, but to give you a brief view of or outline of some of the requirements. And basically, if the landlord is unable to comply with any one of these requirements, then the landlord is unable to use a Section 21 notice for possession. Next slide, please. Section 8 notices. This notice is used as an alternative to Section 21 notice or alongside the Section 21 notice. This notice is used if the tenant has breached the term of the tenancy within either the fixed term or periodic rolling contract, and the landlord wants the tenant to leave. The landlord will have to rely on the grounds 1 to 17 under Section 8. Section 1 to 8 are mandatory grounds, meaning if the landlord can establish one of his grounds at the hearing, then the court has to grant possession as their mandatory. The most used mandatory ground is ground 8, which applies to rent arrears of 8 weeks or approximately 2 months. Grounds 9 to 17 are discretionary grounds, which means the court has to exercise its discretion as to whether to grant possessions based on the information before the court, and the landlord having to demonstrate that it is reasonable in the circumstances to grant such order. The notice period required for Section 8 notices depends on the terms of the tenancy breached and could range from 2 weeks to 2 months. Our legal aid contract ensures that we're able to advise and represent on possession matters up to defending proceedings in court. Well, with the, perhaps the most significant impact of COVID-19 applies in this area, in possessions. Okay, the provisions of the Coronavirus Act 2020 in relation to possession proceedings came into force on the 26th of March 2020. The following day, so first of all, I need to inform you, even though the provisions are in place, it's constantly changing. In fact, there is an update, I think yesterday as well, on the 21st, if I'm correct, yes. Right, so the following day, which is on the 27th, the Master of the Rolls and Lord Chancellor issued Practice Direction 51Z. So that's, this is the civil procedure rules, which took effect immediately from the 27th of March. This practice direction now has stayed all possession proceedings for a period of 90 days from the 27th of March until the 25th of June. So any possession proceedings in courts now have been stayed. So this is obviously trying to work in tandem with the government's guidelines of the stay at home, and obviously no one being made homeless at this period. So during the pandemic period. So there is a stay of possession proceedings in all courts for a period of 90 days from the 27th of March to the 25th of June. So this also means notices of 2 months. Remember, I told you to keep that in mind. The Section 21 notice was 2 months, which the landlord had to give. So now this means notices of 2 months which landlords were required to give under Section 21 before are now extended during this pandemic to 3 months, which equates the 90 days suspension. So any landlord giving a notice, so the landlords can still give notices as normal, but at present, any notices that are given under Section 21 has to be for 3 months. There are exceptions to the 90-day rule. This applies to directions agreed between the parties. Okay, so this just, even though there's a stay of possession proceedings going ahead in the courts at present, this does not apply to directions which were agreed by the parties, okay, as to how the matter would progress. So matters still carry on progressing between the parties, as in maybe exchanging witness statements or disclosure documents being exchanged. So those directions still proceed as normal. So it is noted that the practice direction provides that the state does not apply to applications for case management, which is what we spoke about, directions, which are agreed by all parties before the suspension. So the courts will continue to deal with agreed case management directions, which will be undoubtedly come as a welcome to landlords, as parties to an existing claim can now be confident that the court should deal with all agreed directions. So you can carry on, the parties carry on with the directions as normal, filing to the court, serving upon the other party. So what this also does is that it adds additional weights to attempts to encourage those acting for the defendant, which will be, in our case, will be acting for the defendant, to agree such directions with the landlord's party in order to further the overriding objective for the court, which is to facilitate efficient management of the case once the stay is lifted. Because you can imagine there would be an avalanche of cases, backlog of cases once the stay has been lifted. So the aim is, rather than clogging up the system, the case management carries on. So it allows the cases to proceed normal after the stay has been lifted and avoiding delays in proceedings. Paragraph 3 of the practice direction 51Z, which imposed the 90-day suspension claim, has now been amended. As I said, there have been updates as recent as yesterday. Has now been amended to clarify that possession proceedings may still be issued. So that's a further amendment to the 27th, which initially imposed a 90-day stay. A new amendment, as I yesterday states, that possession proceedings may still be issued now, even if it will be stayed. So it doesn't stop a landlord from issuing possession proceedings against the tenants, but it would be stayed. It would not be dealt with. Landlord can still issue it. However, the Ministry of Housing, Community and Local Government Guidance, Coronavirus Act 2020, and renting states, we strongly advise landlords not to commence or continue possession proceedings during this challenging time without a very good reason to do so. It is essential we work together during unprecedented times to keep each other safe. So probably one of the reasons, good reasons might be maybe for antisocial behavior. That would obviously be one of the good reasons. And maybe the antisocial acts is of a serious nature. Next slide. Okay. What I'll do now is I would pass it on to my colleague Priya, who would introduce herself. She would talk about disrepair and eviction, and then I would carry on with the next slide, which is showing at the moment. So Priya's talk is not on slide. I'll carry on with the next following unlawful eviction. We're talking about Protection from Harassment Act as it applies in a housing context. So I hand over now to Priya to talk about disrepair and unlawful eviction.
Okay, hi everybody. My name is Priya and I'm a trainee solicitor with DLS. So as my colleague said, I'll start with disrepair and then I'll talk about eviction afterwards. So housing disrepair is where a rented property is in need of repair in order for it to be safe and suitable for tenants to live in. Where a tenant lives in accommodation, the landlord is required by law to ensure that the house they live in is in good state of repair structure. The house is free from damp and mold. The drains and gutters are clear and working as they should be. There is a working heating system. There is safe access to electricity, gas and water. There is working sanitation facilities, for example, toilets and sinks. And the home is free from vermin or insect infestation. Where repairs or works are needed, if the landlord fails to carry out the work within a reasonable amount of time after the issues are reported, this could be considered disrepair. It is the landlord's responsibility to ensure that the home is fit for human habitation, and this means that it's safe, health and free from damp, mold, leak and infestations. Section 11 of the Landlord and Tenant Act 1985 provides that landlords of must keep the structure and exterior of the home in repair. So the kind of repairs that could constitute housing disrepair can include the following. So damp, and this will be rising damp, which can cause issues with plaster, skirting boards and flooring. It is the landlord's responsibility to fix that problem. Mold, condensation, leaks, missing or loose tiles, structural cracks, insect and vermin infestation, vegetation growth and build-up on the exterior of the building, boiler issues, faulty heating system. All tenants are entitled to a functioning heating system, no running hot water or heating, unacceptable noise levels. If stairs are unsafe due to handrails, or loose flooring, this can cause a trip hazard. Drainage issues. The landlord must fix any broken or faulty guttering, downpipes or drains. A property, it can be really harmful to someone's health if it makes a well person become unwell, or if it worsens the health of already sick or disabled person. Disrepair can be a form of statutory nuisance if it can be harmful or something that is likely to cause harm. The Homes Fitness for Human Habitation Act means that repairs are contractual and any breach of contract allows the tenant to take action. Now, there are some responsibilities that tenants have, which are any owned appliances or furniture, damage caused by them, their family or guests, minor repairs agreed in the tenancy agreement, safety checks on electrical appliances that they own, keeping their garden or outside areas in a reasonable state, and minor maintenance, which can include changing light bulbs or smoke alarm batteries. Now, there are two stages to a disrepair claim. The first stage is to ensure that all the repairs to the tenant's property are completed. And the second stage is to determine whether the tenant will be able to obtain compensation as a result of having to live in those poor living conditions. Tenants may feel that they shouldn't pay rent when the repairs are a problem. They should not withhold rent. They may be able to negotiate a rent reduction if the repairs are causing problems. The tenants generally do not have an automatic right to stop paying rent, and if they do, their landlord can take steps to evict them. What the tenant can do in those circumstances is that they can write to the landlord and ask for a rent reduction if their everyday living has been disrupted because of disrepair. The rent reduction can be considered reasonable where they've had to perhaps take time off work, they're unable to use a part of their home, there's been excessive and ongoing noise, and their health has been affected. The tenant must allow access to their homes at reasonable times if the landlord or someone acting for them wants to inspect the condition of the property. The tenant is entitled to at least 24 hours written notice of an inspection. With legal aid, the funding for legal aid cases is now only available where there are outstanding repairs at the property. Legal aid is no longer available for the compensation element of the claim. For us at DLS to take a case on for ongoing disrepair claims, there must be a serious risk to the tenant's health. This is quite a high threshold, and we would need to see medical evidence from the individual's GP or consultant. And this is why it is really important for individuals, as soon as they spot disrepair, to take photos and to communicate these matters to the landlord. Contact should always be made by email, text or letter so that there's a record to show. We understand that this is not always, it can't always happen because of someone's disability. So where the individual cannot use this form of communication, they can make the contact by phone, but ask the landlord to write it themselves and send them a copy. This will be seen as a reasonable adjustment under the Equality Act. Legal action is generally seen as a last resort, and the individual will need to prove that they have made concrete efforts to resolve the issue first with the landlord. There is something called the right to repair scheme, and this is where if someone is a council tenant, they can use the right to repair scheme to get small repair jobs done quickly. Only small repairs are covered under this scheme, and they must cost less than £200. And these sort of examples can include unsafe plugs or electrical wiring, blocked sinks or toilets, leaking roofs or pipes. There's no real set time on how long these claims can take. This does depend on the landlord and how responsive they are. In terms of what is considered good evidence is letters and emails to the landlord, photos of disrepair and damage, receipts for items that the tenant has had to replace, medical reports. If the home has been assessed by environmental health, then the tenant can use the inspection report, and expert reports like damp experts, building surveyors, plumbers or builders, and the GP. In terms of coronavirus and housing disrepair, there may be a slight decline in the number of new claims in the short term, but this may rise again once restrictions are lifted, and landlords will still need to deal with those claims that have already been raised, whether they're pre-claims or currently in the court process. The main difficulty in these times that we are in at the moment will be undertaking inspections and the completion of the works. The protocol requires that for completing repairs to be made by a landlord is generally within 20 days of receipt of a letter of claim or a report of any expert. Now, this may not be possible now because of many factors, such as tenants' reluctance to allow anybody in their home if they're shielding, for example, or if they're self-isolating. The unavailability of in-house surveyors due to illness or their own employers' policies on external work during this crisis, and the unavailability of independent experts to conduct inspections. Landlords will need to give careful consideration to what they can promise to do at the moment in terms of works and when they can complete these works by. If the repairs by the tenant are minor in all the circumstances, it would be unreasonable for tenants to be demanding that the work is done at the moment. There are a few questions that landlords will consider during this crisis, which are if any of the repairs are damaging to the health of the person, and if they pose an immediate danger to the occupants of the property, what work can be completed to reduce those risks, and how can the risk of contagion be minimized whilst the contractors are on site, and realistically, when can those works be completed? If a tenant does choose to issue proceedings or apply to enforce the terms of a settlement, which includes agreement to complete works by a specified date, and there's a delay, these tenants may be exposed to criticism from the court and potential penalties, including cost orders, given the crisis that we're in and the problems that people are having. It would appear unreasonable for tenants to seek compensation for any period of delay in completing works caused directly as a result of the stay-at-home policy and the COVID-19 pandemic generally. I'll just talk now about eviction. Landlords are required to follow correct procedures when they evict tenants. It is illegal eviction when the landlord forces you to leave by threatening or harassing you, physically throws you out, stops you from getting into parts of your home, and changes the locks whilst you're out. If someone is a tenant, the landlord would need to get a court order and ask bailiffs to evict them. And bailiffs can evict someone where they're a private tenant, a student living in halls, or where they live in the same building as the landlord but do not share living accommodation, and where the person is a council or housing association tenant. A landlord can evict someone themselves and will not require a court order where the individual is a lodger, in a council or housing association hostel, in emergency accommodation that the council provided whilst assessing the person's homeless application. If the landlord evicts the person themselves, they will need to provide a reasonable notice period to leave, and the contract or agreement should set out how long this should be. The steps that someone can take when they've been illegally evicted are to contact the police, contact the council for advice and support, apply for an illegal eviction injunction, ensure that they have their belongings back, take action to get the deposit back, and apply for compensation. It's always best to advise somebody to get legal advice to find out whether they've been evicted illegally. They should not try to get back into their home if new tenants have moved in, they're not sure whether their eviction was illegal, and there's a risk of injury or violence to themselves or others. The person can contact their council's tenancy relations officer or housing team, and they may be able to negotiate with the landlord to let them back in, or prosecute the landlord for illegal eviction. The person can also contact their homelessness team if they've been illegally evicted from their home. When this happens, the person can apply for an injunction to the court to get them back into their home or to stop their landlord from harassing them. They can also apply to the court for compensation and damages, and at this point it is best to check if the person is eligible for legal aid so that can do the work for them. And if they're not eligible for legal aid, they may be able to get a solicitor to work on the case on a no-win, no-fee basis. A colleague talked a bit about the Section 21 notice. So that's the notice that the landlord needs to give to start the process to end a tenancy. Someone can only be given a Section 21 notice to end an assured short hold tenancy, and the notice must be on a form called 6A. And this must give at least 2 months' notice and follow certain rules to be valid. The person will still be required to pay rent until the Section 21 notice expires. The landlord may have to apply to the court for a possession order if the person stays past the date given on the notice, and they have to do this within 6 months of serving the Section 21. So if a person feels threatened by their landlord, they would need to call the police. And if they've been illegally evicted, they can inform the police that the Protection from Eviction Act 1977 makes it a criminal offence for the landlord to evict them without following the correct steps. It is best for the person to show the police the tenancy agreement to show proof that they are a tenant, and the police will come to the home if they can prevent violence or a breach of peace. After an eviction, the individual must get their belongings back to be allowed to collect them. The landlord cannot keep, sell or destroy the person's belongings, or keep their belongings because they owe rent, or just leave their belongings on the doorstep. If the person's belongings are lost or damaged, they can claim compensation through the court. When getting tenancy deposit back, where someone is an assured short hold tenant, their tenant deposit would have been protected with an authorised scheme, and they can use the scheme's deposit resolution service to get their tenancy deposit back. The individual can take their landlord to court for the return of the deposit where the deposit was not protected with the scheme and where the landlord refuses to use the resolution service. So how does someone apply for an injunction? They would need to use form N16A to ask the court for an injunction or emergency injunction. With an emergency application, they can apply to the court for a without notice injunction if they have been illegally evicted and they are homeless or at risk of violence. It is really important to find a solicitor immediately if they want to apply for an injunction and to check if they qualify for legal aid. And as you would know now that we cover this area and we can help in these types of cases. To apply for compensation, form N1 is used to apply to the court to order the landlord to pay the compensation, and this can be claimed by itself or alongside applying for an injunction. And the amount of compensation does depend on the tenancy type and the landlord's behaviour. Now, with coronavirus and eviction, all tenants are entitled to 3 months' notice, and this does not apply if the person got their notice before the 26th of March. All court action for eviction has been suspended until the end of June, and landlords cannot take any action at this time. So that's it from me, and I'll pass it back to Ola to talk about the Protection from Harassment Act.
Hi, I'm back again. Yeah, just to carry on from where Priya left off with the unlawful eviction. So basically, if the landlord does carries out an unlawful eviction, there's certain things the tenants can do, which leads into the Protection from Harassment Act and injunction. As I stated before, injunctions would be in the context of housing. So the harassment is when, basically when someone behaves in a way which makes you feel distressed. So if the landlord has behaved in such a way, or humiliated or threatened a person, it could also be someone you know, not just a landlord. It could be a neighbor or people in your local area. It could be a stranger. Stranger, for example, on a bus stop. However, as I stated, though, the harassment we cover has to be in the context of housing. So it would just be someone threatening you on the street who you got no idea who they are, never met. So that would obviously come under maybe a criminal aspect. So we're more talking about the civil aspect as an harassment between a landlord or a neighbor. So examples of harassment include unwanted phone calls, late letters, emails, visits, abuse and bullying online, stalking, verbal abuse and threats, smashing windows or using dogs to frighten you. So each individual has to be free from harassment accordingly, and the person must not pursue a course of conduct which amounts to harassment. Next slide. Next slide, please. We can advise and assist with such claims from securing injunctions, as my colleague said earlier, in the context of housing. So an example is, as she stated, where an individual returns home and has found that the landlord has changed the locks, or where the landlord has forcibly removed the tenant from the property, or the landlord threatens the tenant. Okay, so such tenants are entitled to actions to address the harassment, to regain entry, to stop the landlord from continuing with the threatening behavior. As I said, the harassment could also involve a neighbor, and actions taken could range from simply writing a cease and desist letter to the neighbor, alerting the neighbor that the harassment must stop, offering mediation and consequences if the harassment continues, notably to court action. Courts and tribunals hear matters relating to urgent and vitally important issues such as deprivation of liberty, public safety and individuals' rights and welfare. Hearings related to such issues will always be prioritized. This means that although not all courts remain open for business as usual during this COVID-19 pandemic, some courts are open to deal with injunctions as well as breaches of injunctions, suspensions of warrants or possessions and orders dealing with issues of care, adoption, emergency protection, and death and court or protection matters related to vulnerable people. So even though the courts have suspended possession matters for 90 days, some courts are still working and are all to deal with issues such as injunctions. So that is still open to deal with. Next slide, please. Okay. Council. So the next final one is antisocial behavior. Council and housing associations can evict tenants for criminal or antisocial behavior caused by the individuals or their family. Social provider has to follow rules, and failure to do so mean a challenge to the eviction. The landlord may also apply for injunction in the first place to stop the antisocial behavior continuing. That might be more advisable. And the landlord must use an eviction always as a last resort, especially in this pandemic period, and must prove one of the grounds for possession, which are mandatory or discretionary grounds. So we are able to provide assistance in this sort of area under our legal aid contract. So generally, with the local authority, we initially write to the individual, notifying them of an intention to apply to the court for an order against the individual. It's best and vital, basically, at an initial stage to enter dialogue with the social provider to avert the matter progressing beyond this stage. But if the matter to proceed and the local authority or social provider, as we say, are unwilling to bend and want to go ahead, then we are able to, under our certificate, legal aid certificate, to offer full representation to defend the possessions. And basically under the defending claims against the individual for injunctions brought by the social landlords under Section 153 of the Housing Act, or injunctions sought under Section 1B of the Crime and Disorder Act and the Protection from Harassment Act 1997. So the impact of that COVID-19 on ASBOs is basically the same as on possession proceedings, as in stays there's a stay on possession proceedings for 90 days. So the antisocial behavior grounds is one of grounds for possession, as I stated, and that would obviously apply. And the court can only evict on mandatory and discretionary grounds. So just quickly say, discretionary grounds for possessions, the court can decide not to evict only on a discretionary ground if you attend the court and can show that the antisocial behavior has stopped or will stop. And the court may then suspend the possession order in that situation. So which means you can continue to remain in your home as long as if you agree to stop harassment and your visitors, also to stop harassing or causing a nuisance or antisocial behavior in the area. And your children also causing antisocial behavior in the area, that is also brought to a stop. So you have to show to the court that it's unreasonable to grant it because you're able to just demonstrate all this. Next slide. I'll find the slide. So the mandatory grounds, in serious cases of antisocial behavior, the landlord can still use a mandatory ground to evict you. The court can't stop an eviction if your landlord can prove a mandatory, can't stop an eviction if your landlord can prove a mandatory ground. Okay, so what the court will do is, in that situation with a mandatory ground, then the court would have to make an outright possession, as long as the landlord has followed the right process and can prove that following that the convictions of a serious offense or nuisance in this area, or there's a breach of a nuisance injunction or criminal behavior order against the individual. So that's, in a nutshell, is what we do under our Disability Law Service and the impact of COVID-19 on those areas. Can open up to questions, a few questions in the time we have.
Thank you so much. Thank you to both of you. There were some questions specifically around the homelessness you talked about. So one was, have you had any success in forcing a local authority to accommodate a homeless person who were not in PN?
At the moment, we've not had a situation where there's anyone who's been provided temporary or interim accommodation in the pandemic period. But on a whole, we have had a lot of success in obviously providing representation to reverse a homelessness decision which went against an individual, but not in this pandemic. We haven't had an incident of that at the moment.
And then just a follow-up for that was for non-PN applications for assistance under Part 7, and the local authorities try and find suitable accommodation. Is that a power of guidance, or is it a duty that a local authority has to do?
To find suitable accommodation, they have to. They have, it is a duty to find. There is a duty to find suitable accommodation.
So it is a formal duty.
Yes, yes.
Okay. Brilliant. And then there's a few organisation questions. So one is, where is the Disability Law Service based, and where would you take referrals from?
We're based in Oval, near the cricket ground. That's usually the best way to describe it. We're about 5 minutes walk from the critical one. You know?
Yeah.
And
That's
we take
around the London area
from...
for the rest of us northerners.
Sorry?
That's around the London area for the northerners.
Yes,
that are
it is
listening.
in London. Oh, sorry. It is in the London area. Sorry. It's in South London. Yes.
Yeah.
And I'm sure you'll be able to provide our address if anyone needs it. Okay. And basically, we take referrals either directly, okay, or through from other organizations or charities. Yeah. So we have.
And you could take referrals from anywhere across the country.
Right, we can take referrals anywhere around the country. We can we can offer advice. Okay.
Yeah.
If it involves representation, because we have a legal aid contract, then we, provided it's across London, we can do it, and maybe in the surrounding areas of London. The problem with representations is because we would have to justify to legal aid why we're taking on that case, because you would expect the legal aid providers in those all areas should be able to take those cases, because we would have to charge for our travel time and all that as well. So sometimes we can't offer advice over telephone what to do, but it's a bit more difficult when it comes to representation.
Formal representation. Yeah.
Yeah.
And then the other one was, do you just deal with people who have a disability, or would you take referrals, for example, from a young person or people who were destitute and have no payments but are not actually disabled?
Right. Generally, we set up to deal with disabled persons, the adults, children, and the carers. However, what we've done is during this pandemic period, we are taking calls for anyone, regardless of whether they're disabled or not.
Yeah.
Does that answer that?
Yeah, that's great. And then somebody's just come up now and said, what does PN stand for? A PN application or non-PN application?
PN. Okay. Hold on, bear with me. Just check. I'm trying to get it.
Priority need. Somebody's just answered it. Yeah, Jane's answered it. Thanks, Jane.
Yeah. I was trying to see if I was gonna. Oh, okay. I was gonna try and get a proper definition, but I suppose that would suffice. Okay. Yeah. So was there a question about that? What you wanted to bring up on that?
Yeah. So Lisa, do you want to know anything more about what constitutes a priority need, or was it just the PN? Oh, she's put okay, thanks. So I think it might be that it's priority need rather than the full description of what will be classified as a priority need.
So priority
come back as fine. So there's no other questions on the panel, and I can't see any hands raised. If anybody wants to raise the hand, we've probably got two minutes or so left if there were any verbal questions.
Perhaps I should also include, I know it's a housing, we do community care. So a lot of housing and community care matters are related. So we have a dedicated community care department as well. So a lot of our disabled clients fall into that bracket as well. So just to bring that out, okay?
Yeah. So then just the last one now is there any clarification you can give that a local authority have a duty to non-priority needs? Do they still have a duty there or not?
You mean at the present time?
Yes.
Yes, they have. They still have a duty because the Reduction Act, as I said, the Reduction Act 2017 basically says, regardless of what duty priority the person has or anything, the initial step the local authorities have to take is to assess and provide interim accommodation pending the assessment and then completion of the inquiry. So at the moment, yes.
So yeah, so that sounds like it is.
Yeah. And I would expect that would be more so during the pandemic.
Yeah.
Okay.
That's brilliant. So thank you ever so much. Thank you very much to Ola and Priya for taking the time to come and do this today. As I've said, the webinar will be recorded and we'll get that up on site as soon as we possibly can so that you can share it with anybody that's missed it. Thank you all for attending. Our next webinar is next Wednesday, and thankfully Disability Law Services are supporting that again next week, and that's going to be around the welfare benefits. Thank you for listening. Bye.